Morning.
Oh.
Hello. We are on the record and ready to start. This is the Cosmetology and Barber Examiners Board, and today is Monday, October the 1st. We are starting with the Complaint Committee first, and so I will turn it over to Pamela Spicer.
Good morning, everyone.
Good morning.
Hello, Pam.
Morning. As Roxana said, this is the Complaint Committee meeting. I hope you all have had a chance to review the legal report, and I'll be happy to answer any questions that you have.
I actually didn't have any questions with any of the cases. I appreciate all the work you put into this. The only, I guess, question / comment I had is there data being collected about all of the unlicensed activity? I mean, I just feel every month that's the core of what we're reviewing, and I didn't know if that was being compiled anywhere or reported.
I would have to defer to Roxana on that to see if the board office has any data on that.
So one of the good things with the new system that we have is that the cases are tracked for who opens them, how they're opened, and then, of course, the type of case. If it's coming from an inspector or a consumer complaint, and unlicensed activity is one of those things we're able to measure, not just for this program, but across the regulatory boards. Okay. So if that is a statistic that we'd like to see maybe at the November or December meeting, I can definitely have that run and have it for a period of time. It's by far the biggest number of
I guess I'd like to see if
cases.
you've got categories of complaints, not just that particular complaint, but I think it would be beneficial for our entire group to see sort of what the trends have been and what's going on.
Okay. And my plan had been because this month is very hectic for us and for me in particular, for November, to have some licensing information for us to look at that we haven't in almost a year. So at the same time, I was going to present the complaints, but I may do it two different ways, just total numbers and then by consumer versus unlicensed. I think that's a great question. So the system can do that. Yeah.
I'm just curious because, every month we kind of start seeing trends. I feel like we're seeing a lot more consumer complaints, at least that are on the reports that are coming to your office, clearly sort of outside of our realm of what we are in charge of. But the unlicensed activity doesn't seem to be slowing down at all. And I'd be curious to see the stats from this calendar year versus last calendar year, and if that's available. But I don't want to create extra work for you. If it's reportable data, that'd be great.
Yes. No, we will pull it. I think that's a great request.
Okay. Thank you.
You are welcome.
Does anybody have anything else?
One question about case number 29. I'm confused after reading it. Are they found to be the same, or are they two separate businesses?
Based on the inspection, let me say this. The name of the salon indicates it is one business. The confusion from the consumer is that it appeared to be, when I say locations, it's one address. But it may be that there's the salon, per se, in, let's use a house. I'm giving more of an example, not speaking directly to this. This stems from a consumer complaint. So let's say, for example, there's a house and then not necessarily a separate entrance, but a separate location for the spa. I think there was confusion by the consumer in the way it was laid out, but then when the inspector went out, he couldn't determine it was a separate entity.
So is one license?
Correct. It is one license. I'm sorry. If that's what you were asking, yes, it is one license.
Well, I was trying to establish if it's one location with one license, or if there is a licensed area and a separate one that was unlicensed. But it is one location with one license.
Correct.
Okay.
On case number 20, mobile nail service. Is that a licensed mobile activity, or is that also kind of unlicensed activity that we're looking at?
The information that we have does not support it's a license, but there's no license for this individual or shop, which is why I requested an inspection, because we don't have enough information to know really what is going on with this particular entity, for lack of a better way to say it. So obviously, if there's an inspection and something is not accurate with the inspection, or it doesn't meet the rules, then there'll be another.
Really, the only question I had is a very good report. It seemed like everything was lined up real well.
Do we
What's
need
the
to make a
case number
motion,
on?
or do we just need to present it?
I was
I'm
going to
sorry.
ask what the case number was on that spa salon. I had a question on that
Is
list.
number 29.
29.
On page 7, case number 20. For the mobile that Mr. Gillihan just asked about?
Oh, the spa.
Oh, the spa,
previous one.
29, I apologize.
Yes, 29.
Case 29.
What would have been the violation? I didn't understand that if that was, because you can perform spa services in a salon, right? Providing it falls under the cosmetology licensure.
We received a consumer complaint, so at times when there's a consumer complaint, not 100% of the time, but depending on the nature of the complaint, we'll send an inspector out before it gets to me. So there may not be a violation, but we're sending it out for inspection to determine what's going on in the salon, shop, or individual house, whatever it is, so that then we can determine if there's a violation. So we're not necessarily saying there was a violation on the front end, but at times when we get consumer complaints, we'll send the inspector out.
Appreciate that. I'm sorry if it caused you to answer the same question a second time.
Oh, no worries.
Questions? Okay. Do we need a motion on this?
I think we've normally done a motion from the committee, and then when we present, then the full board goes ahead and votes as well. And this time, I don't think there are any amendments.
Motion to approve the report as presented?
Second?
Got a motion and a second to approve the report. All in favor, say aye.
Aye.
Motion carries.
Thank you.
Thank you.
Thank you.
I was looking for the other half of the report last night. I said, this is way too thin.
I know, for not meeting last month.
No complaints. Good morning.
Hello.
Good morning.
This meeting of the Cosmetology and Barbers Board of Examiners is called to order. Good morning, everybody. Welcome. Let's see here. Let's get our morning started off with a roll call, I believe.
Thank you. Yes, good morning. I will start us off. Ms. Kelly Barger is not here. Mr. Jimmy Boyd, not here. Ms. Anita Charlton,
Present.
thank you. Mr. Frank Ambusa,
Here.
Ron Gillihan,
Here.
Wybeck Ranger, not here. Ms. Judy McAllister,
Here.
Ms. Janie Ross,
Here.
Ms. Patricia Richmond,
Present.
Becky Russell,
Here.
Amy Tanksley,
Present.
Mona Sappenfield,
Here.
thank you. And Ms. Nina Coppinger and Ms. Brenda Graham had let me know they would not be able to be here, but we do have quorum, so we can proceed.
One of the first things we like to do is acknowledge our visitors and guests who've taken the time to come out this morning. So do we have any schools that are represented here today? Thank you for being here this morning. Did you bring any students with you? All these young folks, thank you. Thank y'all for coming. Okay. Any other schools? Good to see you again. Good to see you. Thank y'all for coming down too. Okay. All right. Next item of business is to approve the August 6th, 2018 minutes. Are there any additions, corrections, or deletions? We have a motion.
Make the motion to approve.
Second.
We have a motion and a second to approve the August 6, 2018 minutes. All in favor say aye.
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 Motion carries. Okay. Ms. Roxana, that brings us to you.
Thank you. First, on your iPads under your appearing before the board, if you will turn to page 3, we have a barber school application for reinstatement of a barber school license. If you'll give me just a minute. This has to be read if they do. So give me just a minute and I'll make sure. Thank you. Got before you an application. It's a request to reinstate a barber school license. This school is located in Middle Tennessee with 3,600 square feet, I believe. The business license, curriculum, contingency plan, and the 15 required agreements, as well as the floor plan, were received in the board office. This particular school was revoked January 11th of 2018. The school attempted to be reinstated in April, but the application was not complete. Ms. Winfrey was made aware that the application was pending some items. The office communicated several times via email as well as telephone on the items pending. The completing of the documents for the school are now available on your iPads, everything that has been submitted. I have spoken to Ms. Winfrey when all of the documents came in and let her know that in reviewing the documents and putting them in the system, it came to my attention that the school had been turning in hours. And of course, the license was revoked in January. And so in my communication with her, I needed some information regarding that. Her explanation to me was that the students were attending a school in Murfreesboro. And so an investigator was sent there to review the student files at that school. The hours were turned in with a license that is revoked, so I had obvious concerns and wanted to be able to explain to the board. And so in the investigator going to the school, the owner there has provided, and it is there for your review, a signed affidavit attesting that he did speak to Ms. Winfrey, but explained that he had pretty much walked through the process, that the students would have to sign a contract with him and pay his fees in order to attend, and that's where it ended, that no students from the B. Winfrey Barber and Style College attended his school. And so at this point, I will let you all ask any questions of Ms. Winfrey or review the documents if you want to take a minute.
Roxana, do you have an approximate number of how many students were receiving hours?
Yes, with the school being revoked in January, one student signed a new contract in January and got hours. And then we have hours for the month of February, March, April, May, June. Every month, hours were submitted. In May, 2 students signed the contract, and I believe that's closer to the end of the documents as far as the contracts themselves. So in May, there's no doubt that the school had not completed a full application. The board had not reviewed anything. License number 50 was revoked, and 2 contracts were signed. And the concern, again, is that the students supposedly were going to a school in Middle Tennessee in Murfreesboro, and that could happen. Part of what we request and would love to see is, as a contingency plan, schools working together. But upon investigating, that is not the story that school owner has told us. He said that that did not take place. Students did not attend his school. So among the other questions, we need to determine what to do with the students that have, I guess, gotten hours. So you have before you the revocation as well as the hours reports and all the documents. On page 56 is the January hours dated February 10th, and then the following one on page 57 would be the May hours, the June hours from that May 1st 2 contracts. And again, I was able to speak to Ms. Winfrey to try to understand the situation.
Winfrey, what do you have to say about these hours these students have received?
The majority of those students were students who were doing eyebrow threading and eyebrow blading.
And there's no regulation, I think, for either one of those, because I asked Roxana, and she said as long as there's no regulation, then
If you look at the hourly
doesn't
report,
matter.
these are both barber techs, I believe. They are not eyebrow threaders. And yes, I think some students that she had in the middle, but the hours before you and in February, March, April, May included barbering hours. And you do need a license for barber tech and barbers.
but they're not going to be techs. They thought they had to have a tech license in order to thread. They're Egyptian students, and they thought they had to have a license. I thought they had to have a
When
license.
I'm looking at your report here, it indicates that total hours passed this month, this is just the month of February, after your license had been suspended. During the month of February, you're reporting 220 hours on some students and up to 238 hours on other students where you don't have any authority to award any hours at all. They shouldn't have been attending. What do you say about that?
What did you say, sir?
If your license was suspended, revoked. Your license was revoked in January. These students could not possibly be awarded hours from you in the month of February.
I was under the impression that I was suspended and that after I paid the $2,000, then I was still, okay. But then I was told that it was revoked, which means I've been in business for 8 years and I had to start all over again. I wasn't understanding you had to start all over again. You have to get 15 new students, 15 new contracts. It's everything all over again. But I thought suspension meant you just pay your $2,000 and then you could go ahead and you would still have a school.
Do you have any information where your suspension was reinstated?
No, but I don't have anything that shows that it was taken away.
So again, this is a revocation, not a suspension. So
The revocation order on page 48 is again just for noncompliance and following through with the order, but it does result in revocation if it's not met.
Question. They're only allowed up to 48 hours per week, and in a month's time, that's only 192 hours per month. How can they get more than that and get credit for that?
How can they get more what?
More
I
than
don't
the
hear
48.
well, so you'll have to speak
Okay,
on.
you're in the state of Tennessee. You're allowed to get up to 48 hours per month.
I thought it
Per
was
week.
50 per week. We
It's
were told
48 is the most you can get. And if you can get
thought
them
it was
kids there
50.
for 48 hours a week, I'll shake your hand. But that only comes up to 192 hours per month. So that's still showing a lot of overage hours that's shouldn't even
There's
be
a lot of
turned in.
misunderstanding. The rules, the regs, they change all the time. One person tells you one thing, another one tells you another thing.
Ms. Winfrey, all
hard
the
to
rules
keep
and
up.
regulations are available on the Tennessee State Cosmetology Board website. You can go in there and review those, download them. In fact, you're supposed to have a current copy present in your shop at any time for review by yourself or the inspector if they come in. So the rules are out there. Okay.
On the number of hours, just to clarify, on occasion, with some months as the exception, you do have it a little bit more with one extra weekday. So you are correct, generally speaking, and the 48 hours is 100% accurate. It's just sometimes we have an extra day. So,
Yeah, but you wouldn't get up to the 238.
well,
or the
these
220.
hours are for January. They're reported by February 10th, so they're the January month, and that does happen to be a longer month. So, well, you may be right. You couldn't get the 220. I just wanted to point that out.
238.
Okay. So what we're looking at first, we got a couple of issues here. The student hours is one, but we also have an application for a reinstatement.
That is correct.
Okay.
And again, my concern stemmed from these hours, that because the license was revoked, I wasn't looking at it consistently, and it was missed that hours were coming in on a revoked school. When I looked at it, it's not just 1 month, it is all of them. The course study says Barber Tech, which obviously we license Barber Tech, and you can't give hours if you don't have a license. Some of those hours are for barbers. We do not on threading, so they wouldn't need to be reported, and obviously instructors and school owners should know that. But the communication I received was that the school in Murfreesboro was accepting these students and they were going there.
He and I had discussed that.
That is not the case, and the school owner has actually chosen to provide this board with an affidavit saying that that is not what took place. And that's all that we've got.
Good. Okay, I'd like to come back to the application itself, and as I'm going through here, I'm looking at your contract that you've submitted. I see that there's some things in your contract that are a little bit irregular. On page 4, I see some notations here about dates changing for various reasons and whatnot. I don't see any initials by yourself and the student involved here, so that would not be acceptable. We can't just change things on contracts. In your application, you're indicating that you have 1,900 square feet in your floor plan, but I think, Roxanne, did I hear you say 3,600 square feet?
Yeah, but you can ignore my total square footage.
Okay.
Her contract's probably right. I didn't have it.
Well, in a
updated.
second place on her contract, she indicates that she has 2,200 square feet.
Okay.
So how many square feet do you actually have?
It's between 19 and 22.
Kind of
But
one of
some
the
of
things
it's
we'll
not.
need to know.
Some of it is not usable. You know, storage.
In the student's contract, I see that you have, and I'm looking on page 9 for iPads. I see that you have a more or less a schedule or a scale out here that lists the clock hours and full-time, part-time kind of information. Application fee of $150. Tuition is $8,400, and your total is $8,500. So the math doesn't come out on that correct. You don't have your.
I can correct that.
And as I go through here in a couple of places, I see a reference to a $100 application fee, and in other places, a $150 application fee. That's probably pretty confusing to a student. On our iPads on page 18 and 18, 19, and 20, I believe. This is the cancellation and refund policy. It appears to me that we have a couple of different types of statements here. You've got one description of how refunds or returns or cancellations are going to be handled, and then you've got a scale. That's all in written language, and then you have a scale on page 20 on the iPad. That does not match up with what is written.
If you were to get your contract all in order and where everything matches and it's understandable for the students, because they could come in here and read it one way and you got it something else, I really think you need to have somebody take a close look at your contract and help you with it. I think you really need to understand the laws that are in effect now and maybe try to get that in order and maybe come back is what I would do. That would be a motion for me.
Ms. Winfrey, may I ask you a question? Was somebody overseeing this for you and you were just unaware of some of these behaviors or inconsistencies? Because when I see a DR in front of a name,
Right.
I know you're a bright woman. I mean, you don't just get that degree by being this inconsistent on the paperwork that you probably had to turn in order to get the degree. So for me, I have trouble understanding the level of expectancy and the deliverables. There's a major disparity between the two, and I'm just curious if you have somebody else just doing your work and they neglected the work and you assumed it was getting done right. Because I'm quite surprised.
What I was trying to do was base things on what NACAS had required, because we were trying to go through accreditation, and NACAS wanted one thing, and we were trying to do another thing, and then the state wanted another thing. And we had spent over $30,000 trying to get accredited, trying to do what they wanted us to do.
That still wouldn't have anything to do with inconsistencies of how many hours a student's supposed to be able to go to school and whether they're really going to school in Murfreesboro or not, and one is willing to sign an affidavit that it wasn't really happening. Okay. It's just pretty muddy. It's pretty muddy, and it'd be hard for me to move forward with any of this, guys, based on the amount of discrepancies.
That's what I would do. I mean, I'd make that motion that on the school part.
A motion to deny?
To deny, let her get her stuff together and come back.
You have a motion to deny this application, and again, we need to keep in mind, I think, that this is subject to failure to meet the terms of an agreed order as well. So,
hey, Ron, I will weigh in and say, that agreed order so far, as far as the board's concerned, she has satisfied that particular payment plan,
we'll
and so that's been closed. I think one major issue that I don't think has been addressed by the applicant today is the enrollment of students in May of this year into a school that had a revoked license. And I don't think that particular issue has been addressed today, and that is an outstanding issue simply because there's no way for the board office to know how to handle these students without information about where they've been going to school, who's been teaching them, and etc. That information is lacking. So at this point, we have that situation of an hourly report showing 2 students enrolled in May when the school was revoked, and no way to get in touch with those students or determine how to process their hours or anything. I think that's a concern that the board office has, and something that definitely would need to be addressed at some point.
This in 2 separate issues, one with the application and then do the hours next. Can we do that, Ron?
That's correct. I just really
Okay.
wanted to point out that the prior agreed order, while you definitely can consider that as far as it being outstanding, she has finished paying, and that consent order has been complied with as far as payments concerned.
If the students were going and the school not licensed, wouldn't the students lose those hours?
I think there are a number of questions to be answered. Where were they going? Who was teaching them? What were they teaching? Right now, we don't have any information to be able to look at it and see how the law would address the situation.
Have you talked to the students at all, Roxana?
The hourly reports that we get just have the last 4 of the social. I have no phone numbers, emails, names of the students, no. And again, by the time we did the investigation, I have 2 different stories. So I think we need some answers besides talking to the students. But hopefully, today we can understand what really did happen, and we can go from there. And then you can guide us on what you'd like done.
Let's say we have an affidavit from the alleged school that was offering the hours.
It's on page 59. We sent an investigator there, assuming that they would agree that the story would make sense, and they'd agree, and we'd be able to see contracts at that school as students going and so forth, and you can read that they did not attend that school.
I had a question for you guys in the office. Is when a school's license has been revoked, this is the 2nd or 3rd time since I've been on the board where a school's license has been revoked and students kept attending. or kept receiving hours from that school. How is a revocation handled? What does that look like? I mean, clearly there's paperwork. Is that delivered to the school? How is that communicated?
So in this case, it is a signed consent order that says you will meet the payment plan, and if you don't, you're revoked. So the revocation itself, and Pam can add, is sent to the school once the case is completed and closed and the school license is revoked. In this particular case, Ms. Winfrey did know it was revoked because when she was reapplying in April, there was a reason for the reapplication. It was because her license had been revoked. So via email and phone calls, we communicated she would need to reapply completely. A suspended license could have an end to the suspension, but a revoked license means you've got to reapply. So before April, she was aware that the license was revoked.
Spoke with her personally.
Yes.
And once a license has been revoked, of course, the student should not be attending or receiving hours at all.
That is correct.
And then it would need to go through starting all the way over to get reapproved.
15 for the barber schools, it's the 15 contracts as well, as she mentioned.
Do the inspectors go to deliver anything or to check on?
Not normally. And you're right, we've had one other situation of a license revoked on a school. The school owner, for some reason, didn't understand, and we did at some point have to follow up. When you're signing the orders and getting a notice that the complaint ended in a revocation, we don't always go to follow up. It doesn't happen often, but it may need to be part of the course is to periodically drive by and make sure the school isn't open.
I will say in this particular case, I have the notice of license revocation. My left actually sent that. It's dated January 11th, 2018, and it essentially says that the license has been revoked. It's immediately effective, and she must cease and desist operating the barber school to avoid further violations. And so, in addition to the conversation that Ms. Gamusio just described, there's also written notification sent to the school. We also have several emails from earlier this year where the board office is communicating with this applicant about reopening and reinstating the school. I have one from March 28th where we're talking, Ms. Gamusio is emailing this applicant and attaching a copy of the application for her to complete. I have another email from early April where a staff member in the board office is acknowledging receiving the application back and addressing issues that were outstanding with that application. And following that is when we see students enrolled. Fast forward to May 17th, more emails from the board office to her, this particular applicant reminding her to go ahead and complete the school application in order to be presented to the board by a certain date. So I want the board to understand the ongoing nature of the communications prior to the school being, prior to these students being enrolled, and kind of the timing of an application being submitted in, early April, students being enrolled in early May, and no approval to reopen or reinstate happening in between that time period.
So, really, we can't accept their hours as a board.
I think as far as the hours are concerned, we have to have additional information because, for example, one key question would be, who was teaching the students? Was a licensed instructor teaching the students? Or we literally have no information other than the students.
Or was anybody teaching the students? We don't know that either, do we?
Well, we have no information other than the students' names and the purported hours that they completed at this time.
Ms. Winfrey, those students were on a monthly hour report submitted by you. Were they attending your school during the month of May?
Yes, some of them were at the barber shop. We had a barber shop that was connected to the school.
Okay.
And sometimes they would go there and work instead.
Okay, so you've got students who are enrolled in your school who are working in your barber shop without a license.
But they
That's
were
what
doing,
you just said?
I understood that if you in the apprentice program that you could do that. I mean,
Well,
Are you
it's kind of
licensed?
irrelevant. You don't have any school, you don't have any program, you don't have any authority to offer anything. So, were those students you're saying were attending your school for the month of May, and that they worked in your barbershop as well?
yes, it's right next to the school.
Okay.
So can we ask the question who were teaching the students while they were receiving these hours while the school was revoked?
AT,
JT.
JT, we call him JT.
What's his name?
Martin.
Martin Martin. And the first name?
Just call him James, JT, James.
James Martin. And he's a licensed instructor,
Yes,
barber instructor.
yes. As well as Marquise.
Marquise. Could you spell that for me?
Marquise.
Last name?
Martin.
Martin.
Both of them are named Martin.
Okay. And both of them are instructors?
One has his own barbershop. Well, they both have barbershops. But
Were they aware that the school license had been revoked?
Or was that a yes? Was that a yes? I didn't hear you.
I said no.
Do you have any office personnel that helps you kind of organize your office and read your emails from the state board, or is it just you?
It's basically just me doing everything.
Okay. I do apologize. I came in a little late, but could you tell us the reason why you continue to run the school and the license were revoked?
Because I thought I was just suspended, and that once I paid her the $2,000, then I could continue to have a school. That's what I thought. I've never been my school has never been suspended ever in the 8 years that I've had it.
So just so it can be stated, Chairman, when the school is suspended, the operation still can run?
No, that is,
See,
No.
don't nobody.
Right now.
Okay.
And I think part of the concern is that we have a communication showing that a new school application was submitted in early April, and these students were enrolled May 1. And so it's kind of difficult to put the timeline together in the sense that the person, this particular applicant was revoked, submitted a new school application, enrolled students prior to getting approval. I think the lack of knowledge argument is difficult to make because we do have an application that's being submitted for approval. So I think that kind of negates the lack of knowledge argument to a certain extent.
Well, to an extent enough that if you thought you were just under suspension, you would never apply for a new school.
In addition to that, if you're under suspension, you cannot operate the school.
And is that the very first time the school is on suspension?
Yes, and our mean scores are higher than the state scores when they take their exams. The only area that we were a little weak in is the coloring, because, you know, a lot of students don't like coloring, but we've never been suspended or revoked or anything. This $2,000 set us back because we're just a little bitty school. We don't charge $20,000 to go to school. I don't think that any child should ever pay $20,000 to go to barber school.
Did you ever close the doors of business?
Did I ever close?
Yes.
Yes, I have, because it got too dangerous. You know, someone was killed in the parking lot.
No. What I mean is, for clarification, did you ever close the doors of business due to your school being suspended or suspended in your understanding, but in actuality revoked?
Yes.
How long were the doors closed for business before paying the $2,000?
I don't know. I'm just guessing. I'm not sure.
And you reopened the school after paying the $2,000. Had you talked to Miss Roxana? What prompted you to open the doors back up for business?
I didn't close them. I thought you said, did I ever close the building? Yes, the building is closed now.
No, ma'am. Closed business.
The business is closed now. Is that what you mean?
No, the operation of business together. The license is revoked. The license is suspended. Did business daily operation close down until this situation was handled?
It closed down, yes.
For how long?
I can't tell you how long it was. I really
Okay.
don't remember how long.
Who could? If you can't tell us how long, who could?
I don't know. You all can go ahead and just revoke it. I'm fine. Y'all do what you want to do.
The hours of the students, right?
I think we do need some explanation
think we
and a
do.
decision from the board on the hours for the
Right.
students, if nothing else.
I really don't think we could take them unless we had more information on it.
Where would we get the information on the students?
Does legal have a recommendation of what we should do with these hours and students? Or are you as baffled as we are?
I mean, it's literally a situation where you all would have to have some information in order to be able to look at these hours and determine if you can, in this situation, give credit. We would have to know more about what's happened here. Typically, kind of our authority comes from, the complaint process, unless, the information were provided voluntarily. I mean, one option would be for the board to kind of authorize us to reach out to this particular applicant and see if the applicant is willing to provide us with enough information that we can kind of independently verify. That's certainly one option. We're not sure how cooperative the applicant will be in, providing information on a voluntary basis. And
Considering that we're not getting any information that we can make a educated decision on, I think we have to go to the next layer of possibility, and in this case would be the student. Otherwise, we're just guessing, and I'm not willing to.
Is there a possibility that we could contact the instructors that were named and mentioned?
That is the thought.
Yeah.
We could go back to even older reports that hopefully the instructor's information was submitted on. Some of these just included what you're seeing, which is for our school owners, they would realize you're missing the instructor piece and we didn't get it. But we can do some research and try to find instructors that fit those names.
I'm curious if they're certified or in progress instructors.
that would have to be verified. Would have to verify and see if these individuals are licensed at this time as instructors, and
Which would bring another layer, because if they are and they're teaching outside of a licensed school, now that is a regulatory issue against their license as well.
I suggest that we authorize you all to contact the applicant to see if they would be responsive in giving the information needed, and also verify the instructors named before and see if they have any information to give as well. And not only are they instructors currently, but were they licensed instructors at the time this was going on? That's my suggestion.
You'll have to hold that for just a minute, because we already have a motion on the floor that we have not. It's been properly seconded, and we're having discussion. So the motion was to deny this application. So on that particular question, we need to vote on whether to deny this application for this school. All in favor say aye.
Aye.
Opposed say no. Motion carries.
Have a second on that?
It was.
I will. I was going to.
She did. She did.
We both missed the second. Thank you. So we have a motion by Ms. Patricia Richmond and a second by Ms. Judy McAllister, and all voted in favor to deny the reinstatement. Thank
Now
you.
let's take up the issue of the
Yes.
student hours. With the student hours at this point, we have no indication that any legal hours were given or were appropriately recorded for any student. We have school that was not authorized to be in operation. We have a secondary school that had been spoken to. Would they be willing to take on students in the meantime, I presume? And we have his affidavit that he did not enroll any of those students, nor did he teach them or issue any hours to them. So at this point, we have students who have speak to them in his affidavit. He didn't speak to them. So we have students who have not asked for any hours. They've not sent a letter to the board. The students have not requested anything, have they?
Not to this date. Now, we've got a few that at the January hours that were turned in on February the 10th were pretty high up there. I've got one applicant with 1,433 hours. It is very possible that that applicant, without us noticing, the month of February would have gotten enough hours to be put through the test, and that would be, a whole other situation. That frankly, all this kind of hit me the last week, and so I've been looking at it from every angle and not finished doing the research. But that particular applicant could have already passed the exams, and in that case, we would look at it differently. But
We have a way of flagging these students' names and social security numbers.
we don't have the full social security number. So the situation with students, because we have so many in the state and we're the licensing board, is we don't enter them in our system until they're getting a license. So we see them on the hourly reports, but we don't have enough basic information. We don't have, by the time they pass, the name might have changed, middle and initial, they may have, changed the last name altogether. We need date of birth, we need the full social, and so really we don't have all those pieces until they're ready to be licensed.
Hello,
Would this be reasonable?
Roxana.
Yes,
Sorry,
ma'am.
Go ahead.
Hi, it's Mona Sappenfield. I was researching according to her spelling on those instructors that were teaching for Miss Winfrey.
Yes.
And I did find Marquis Martin and from Smyrna, Tennessee. And so he's a master barber and an active instructor. We might be able to get some more information by maybe reaching out to him to find out, what he's been teaching, where he's been teaching, and some information on that school if he would be willing to, give us that information.
I believe Ms. Granger had suggested that with both of them. So thank you for while we're here looking it up. So that's perfect.
Yeah, I was not able to find the J.T. Martin. There was no one, but it could be another name.
James. Yes, we'll look under Martin and do a search. But it's good to know at least we've got one of the two. Thank you.
Yes.
Well, we licensed a school for Marquise in Smyrna. He has his own school now. Last year. So,
Okay.
but that's possible. I know that he had worked for the Winfreys previously. So I don't know if he was working with them during this time or not. But you could ask him.
Yeah. Yeah, he's licensed through December this year. So. Active.
Okay. So with regard to the students that we have right here in front of us now, I was saying I don't think that we can legitimately offer them any hours. They haven't requested it through the board. At this point, to deny those would be kind of a moot point. If they have an issue, if they come back before the board and request that, then we'll take those up individually perhaps, case by case, and see if they can provide any evidence or proof. But remember, if they're attending somewhere outside of that school, those hours aren't valid. If they're program, those hours aren't valid. If those instructors are teaching somewhere as an instructor outside the school, that's also a problem. So,
And I don't know, again, not having all the pieces, I don't know that is a really plausible explanation. The hours aren't turned in as apprentice hours. For those of you that aren't in the schools, we actually ask that the hourly report include the A's so that the office can have an idea of who is out there in the shops as apprentices. They have to pass the theory exam. That's not been the case. So I don't know that explanation will fall in line. But we will look at all those avenues and then take them case by case.
Yeah, I think I'm going to challenge us all to figure out a better way to communicate this, because I feel, because this is not the first time this has happened, that these schools are being revoked, and the owners of those schools aren't communicating that to the students or to the instructors. And while, yes, I feel like the instructors should make sure that the school is active, clearly that was not the case in this incident, and I don't know that those instructors even knew the license had been revoked. So I don't know how we can publish that, Roxana, or, I just feel horrible that these students presumably paid for these hours that are not valid. And how do we get that out to the students who are the ultimate victims in these instances?
All they could do is try to get their money back from her per
Presumably.
hour. Yeah.
If they contact the board, then we could suggest they or offer them the idea that they can pursue it civilly.
Steal the money.
If she had problems getting the $2,000 to pay to the board, or,
I do agree with Amy. Is the students that fall short of the entire thing, but whose responsibility by law, not to seem harsh or insensitive, to notify these students that the school has closed? Or are you saying that we probably need to implement something that the students are contacted to know if the schools are revoked or suspended?
Well, I guess I know it's probably on our website, but if the folks come to me a lot and ask about barber schools, and who's licensed and who's not, or where to go, I think it would be helpful because, of course, we always recommend a few schools that I know are well run. Hi, Mr. Ron. And follow the rules. But I think it would be very helpful to have a list on the website that's easy to find that just says, these are the current schools licensed in the state of Tennessee. And before you enroll, please make sure your school is on this list with a current active license so that, the hours that you're paying for are legitimate.
And it also brings up a thought in my mind that if you're already enrolled in the school and business is going and then something happens as such and nothing is told to the staff or the students, then they think everything is okay. So again, going back to the question I asked, whose responsibility by law is it to notify the students that these hours are invalid? But I know that there's no complaints right now. So we're kind of, dealing with a ghost complaint, but they're bound to come up.
I think part of what we did with this one, with trying to determine where these hours were accrued by going and having the investigator speak to the other school owner, I think we could really call that kind of like a preliminary investigation. And I think following up with the two instructors that were mentioned and following up with the applicant to try to get more information, I still think that would be a preliminary activity that the board could be doing to determine what the board needs to do next, because I think there is a very real legal issue happening right now. We're just not sure to what extent the legal issues arise, essentially. And so I think we can definitely, with your authorization, continue investigating to try to determine what's happened with these particular students and bring that information back to the board to further review.
I think if we do a cease and desist order on a school or something, maybe an investigator deliver it to them and let them talk with the instructors also that are there.
Well, this school's
employees.
Already been revoked,
Right.
so there would be
in the
nothing-
future. In the future, maybe.
Oh, in the future.
Yeah.
What I would like to do with that is your concerns are definitely noted. Look at that and come back to the board with a plan of action on that, how to best proceed. I'd like to talk with Ms. Spicer about that, Ms. Gamusio about that, and some others, and get more of a plan together on what we think as far as the board's ability to better inform school revocations, and then move forward with the discussion at that point.
Thank you.
So we had a
I have a motion to give Ms. Gamusio authority to further investigate with the applicant and the named instructors, James Martin and Marquez Martin.
have a second.
I would also add that it may be more efficient, like say, for example, we're talking to, well, it wouldn't be myself talking, but our inspectors are talking to somebody and they maybe give another name, to have the motion broad enough that we can go ahead and talk to potentially that other named individual or school. That way, whatever information we have to report to you all when we come back, we've kind of looked at everything instead of kind of piecemealing it. So I'd ask that you all consider making the motion a little broader so that we can try to get to the bottom of wherever the information leads.
So the motion is the board will give Ms. Camusio authorization to invest the named persons for the applicants and instructors and anybody affiliated.
Just authority to investigate.
Just authority to investigate. Great.
It's okay.
Yes.
Second.
Second.
Okay, so we revised that motion. Any other discussion or questions? All in favor say aye.
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 Opposed say no. Motion carries. And before we get too far away, I did want to say thank you, Amy. I appreciate that. But to be very clear, the board does not recommend any schools or shops over anybody else.
Oh, sorry. I'd like to recommend the schools that are following protocol. How about that, Mr. Ron? I use you as an example, not as an endorsement.
We do have the list always online, but I don't know how many students really search it before starting. So, but we
Are
will look at
suspended
everything.
and revoked schools online as well?
We would pull them. We don't, once
They
they're.
wouldn't be on the list of,
No, if they're suspended or revoked, they would not be on the list. The list is active schools. However, verify.tn.gov, if you look for any school, it would show you currently active, revoked, suspended, anything. So that school would never go away from the Verify website, and that's what I would always encourage them to look for, is to actually pull that license. But the list that we have is just of active schools, because I would hate to have someone there and then the student print it, drop the column that says status and be misguided. So
Yeah.
the list of active is just active. But verify.tn.gov shows everything for shops, schools, the whole thing.
It's a great resource, but it's also tricky to use if you don't know what you're looking for.
Ready? Okay. All right. So on your iPads, we're on to our applications to test. Mine fell asleep. Give me just a minute. Okay, thank you. You have before you an application for Natasha Cosby, Ashley Harding, and Dwayne Reed. The applicants have felonies within the last 3 years and or are currently incarcerated. The request is for them to take the Tennessee examination. So we have submitted their information for the approval of the board. The required information disclosure, students, update, as well as a letter of recommendation are all submitted. The board provides agreed orders for a 2-year probationary period unless you see fit to change that 2-year period with legal counsel's assistance. Once those agreed orders are signed, then we submit them to test and for licensure. I will let you review the records on the iPad in case you have any questions.
Make a motion to approve these applicants to test.
Second.
2-year probation.
With the probation.
We have a motion and a second to accept these applicants with the agreed orders. All in favor say aye.
Aye.
Opposed say no.
Aye.
Motion carries.
Thank you. Next, we have an application for a manicure license with hours from Vietnam for Than Quoc Huy. Mr. Huy has presented his documents shortly after the August board meeting. He had his transcript evaluated by educational credential evaluators. Therefore, he was put through to take the exam so he would not be delayed. On August 13th, 2018, he passed his practical exam. So in this case, we are approving his license.
Make a motion to approve.
Second.
We have a motion and a second to approve the license. All in favor say aye.
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 Opposed say no. Motion carries.
Thank you. Next, we have an application to test as a manicurist with hours from Vietnam for Thuy Lee. Ms. Lee completed 714 hours in 2015, and Aqua International has completed the evaluation stating that the documents are authentic. She is asking, therefore, to take the exams.
Motion to approve her to take the exams?
Second.
We have a motion and a second to approve to take the exams. All in favor say aye.
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 Opposed say no. Motion carries.
Application to test as a manicurist with hours from Vietnam for Nguyen Mai. Mr. Mai has completed 714 hours in 2016. Aqua International completed the evaluation stating that the documents are authentic.
Make a motion to approve him to test?
Second.
We have a motion and a second to approve for the test, and all those in favor say aye.
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 Opposed say no. Motion carries.
Application to test as a manicurist with hours from Vietnam for Vui Than Thao Pham. Ms. Pham completed 800 hours in 2015. Aqua International completed the evaluation stating that the documents are authentic.
Motion to approve.
Second.
Motion and a second to approve. All in favor say aye.
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 Opposed say no. Motion carries.
Next, we have a few licenses that had previously been revoked. The first one is a request for approval of a manicurist license for Kong Nguyen. Mr. Nguyen was licensed by Reciprocity from Texas in 2013. That license was revoked in 2016 for failure to obtain licensure as the statute requires. Since then, he's attended a school in Tennessee and passed both exams. The practical exam was passed on August 2018. You would be approving his license.
Make a motion to approve. He's went through his steps and done it.
Second.
We have a motion and a second to approve. All in favor say aye.
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 Opposed say no. Motion carries.
Next is a request for approval of a license. This is a manicurist license for Tran Than Pham. Ms. Pham was licensed by Reciprocity from Texas in 2013. That license was revoked in 2016 for failure to obtain licensure as the statute is required. Since then, she's attended a school in Tennessee and passed both exams. The practical exam was passed April 2018.
Make the motion to approve.
Second.
We have a motion and a second to approve. All in favor say aye.
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 Motion carries.
Request for approval of a manicurist license for Tommy Tren. Mr. Tren was licensed by Reciprocity from Texas in 2013. That license was revoked in 2016 for failure to obtain licensure as the statute is required. Since then, he's attended a school in Tennessee and passed both exams. The practical exam was passed August 2018.
Motion to approve?
Second.
We have a motion and a second to approve. All in favor say aye.
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 Motion carries.
Thank you. And we are moving on to our reciprocity applicants. I believe we have 4. The first on your iPad starts on page 115. This is an application for reciprocity of a manicure license from Florida for Thiep Lee. Mr. Lee was also licensed in California by reciprocity through Florida between 2003 to 2014. He completed 240 hours in Florida and did not take the state exams as they're not required there. Mr. Lee has worked between 2003 and 2017, but did not work during 2015 and 2016. You've got records regarding his employment, tax information, and then on page 130 is his explanation of 2 years he did not work. My recommendation is that he take the 2 Tennessee exams.
Make a motion for him to take both exams.
Second.
We have a motion and a second to require both exams. All in favor, say aye.
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 Motion carries.
An application for reciprocity of a manicure license from Texas for Darlene Mullins. Ms. Mullins was originally licensed in Arizona in 1987 with 300 hours and both exams. That license expired in 2000. She has been licensed in Texas since 2000, and that is her current active license. She provided letters regarding work experience between 2002 and 2011. She states she is retired since 2013 and wishes to have an active license for the professional discount. So her work experience covers the hours, and she did have both exams. My recommendation is that she be approved for reciprocity.
Recommend we approve it for reciprocity.
Second.
We have a motion and a second to approve for reciprocity. All in favor, say aye.
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 Motion carries.
Next is an application for reciprocity of a manicures license from New York for Mary Nguyen. The certification shows Ms. Nguyen was licensed in September of 2014 with 250 hours and both exams. She's provided taxes from 2012 through 2016, showing 5 years work experience. New York has an apprenticeship program that does allow prior work in the shops before the full licensure. So my recommendation would be that she's approved for reciprocity.
Make the motion to approve.
Second.
We have a motion and a second to approve for reciprocity. Everybody in favor, say aye.
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 Motion carries.
Application for reciprocity of a manicure license from California for Ming Thai Vo. Certification from California shows initial licensure in August of 2007. Once the transcript from the school was requested, the documents provided appeared to be altered. The State Board has replied via email that those transcripts would not be acceptable, but that school is currently in question, and only offered the 400 hours, not the 600 as her transcript shows on page 156. They added that records from this individual had her actually attending a different school, which is now closed. Further, a request of clarification resulted in 2 new transcripts, which have been clearly altered. Those transcripts are on page 159 and then page 160. And those transcripts have her under both names, the last name of Dingler as well as her current last name of Vo. Ms. Vo is also licensed in Alabama since 2007 by reciprocity from California, and I will leave this for the board's decision.
Really, you don't think a lot of these hours may just totally be bogus, maybe? We have no way of really knowing.
California shows that she actually attended College of Physical Arts and Cosmetology, but that school is closed, so they couldn't give us a lot of information. That particular school, and again, it's closed. It's not one that they're reviewing. I don't know if it's because it closed many years ago and there's not much they could do, but the first one that she has on her summary is under review. She's also licensed in one other state, is the reason that I trust the board's decision and conversation about this. So she's been licensed and working in Alabama as opposed to California.
She submitted documents that we can see are altered.
Absolutely.
I make a motion to deny if they're altered.
We have a motion to deny all the altered documents. Do we have a second?
Question first, Ron.
Okay.
Have we ever seen where documents were altered and proved to be legitimate?
No, we had a situation with documents altered from Wisconsin, and then later the state board said that that person did have a license, didn't properly request it, and then altered the certification. Not a transcript so far. Now, we've got a similar sort of thing with Georgia right now with transcripts, but nothing quite like this on the transcript. And part of it may be because California schools, so many of them are right now in question. They're under this big investigation. So the question she'll have that, the board can guide me on is, with an active license in Alabama, would us denying mean that she needs to redo the hours or the exam, or what would we?
We know if she got the Alabama license based on the California.
Yes, sir.
Reciprocity from California, so it all goes
Yes.
back to the root.
Yes, yes.
Licensed in Alabama since 2007.
That's correct.
Is licensed there now?
Yes. Through 2019, and it's through reciprocity with no complaint information.
Because she got in Alabama that way doesn't mean, I wouldn't feel comfortable just jumping on that train. I said just, if she's that good and she's legit, let her take the test, and if she qualifies, maybe her work experience can make up the difference that we're unsure of.
Hours are good.
We don't know
As far as
that
we
the
know.
hours are good.
Okay.
So I don't want to say that. We don't know that they're necessarily wrong, but we do know that the State Board of California has said that they don't show her going to the school that she's produced a transcript from. They show her going to another school. When we questioned that, we got that transcript as well, clearly altered. That last name in the corner is clearly pasted in or somehow. So they're baffled too, because you could have said you went to the right school. And it could be the concern for which schools are on the list, which ones aren't. I don't have the answer, but again, back to what Mr. Gambusa said, if she's working in one other state, has been there for a while, and is currently in Tennessee, if we deny, and we do have a motion to deny, their question to me is going to be, so what do I do now?
She produced the right documents of the schools that she attended.
Closed though, right?
It's closed.
And as Mr. Gillihan said, they're altered, so they could.
We have a motion on the floor, but we don't have a second yet. Do we have a second to deny?
I'm inclined to think the way that Frank is thinking, that if she takes both tests, that's my thoughts.
I'd like to make a motion that we approve her to take both of the tests.
Because we have a motion, Ms. Patty's motion to deny is going to fail for lack of a second. Now, you're good.
I'd make a motion that we approve her to take both of the exams.
Second.
We have a motion and a second to approve to take both Tennessee exams. Any other discussion? All in favor, say aye.
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 Opposed, say no.
No.
No for me. Motion carries.
Thank you. We are on to our miscellaneous applicants on your iPad. Oh, okay. If we could, Ms. Spicer has pointed out, we have a summary suspension that we've kind of left kind of floating, and they are going to call in for it. So we want to make sure, we knew we couldn't do it before 11. So we're there. If we want to take a quick 5-minute break, they'll call in, and then we will have our 2 board members on the phone as well as the individual, and we will skip to the part on the iPads where the summary suspension is.
Okay.
Thank you.
We're going to take a 5-minute break. We'll be right back.
Real 5 or headdress is 5.
A barber's fine. It doesn't exist.
Don't.
I was fine. I'll do another haircut before I take a 5-minute break.
We're back on the record. Thank
We're
you.
back in session.
Thank you. Yes. If I could, we are going to turn it over here in a second to Ms. Pamela Spicer, but I want to get you on the right page. On our agenda, we have under Staff Attorney Report, a summary suspension, and we have the individual involved on the phone with us, which is wonderful. And I want to let you turn to page 198 on your iPad so everybody will be on the same page, and then Pamela will take over. Thank you.
I'll give everyone a moment to find it on the iPads. Mr. Rigsby, are you with us?
Yes, ma'am, I am.
Okay. Also, board members, this morning I passed out the affidavits, which are essentially the warrants for Mr. Rigsby's arrest. But if anyone is missing, if I missed anyone, let me know. There are 4 pages at the top, affidavit of complaint. Does everyone have that? Mr. Rigsby, if any time you can't hear me, please let me know, and you will be given an opportunity to speak to the board.
Yes, ma'am.
Ms. Roxanne, where are we on the iPad?
We're on page 198. If you press toward the bottom, the little pages pop up that you got to press just so.
Are we ready?
Go ahead.
First, let me speak to the board and Mr. Rigsby explaining what this hearing is today. This is a request for a summary suspension by the legal department for Damian Rigsby and In the Cut Barber Shop. Damian Rigsby's license number is 20237. In the Cut Barber Shop license number 11920. Damian Rigsby's address is 218 Dove Lane in Franklin, Kentucky, and the shop address is 2070 North Broadway, Portland, Tennessee. Mr. Rigsby contacted me this morning on the landline stating that he just recently received notice of this hearing today. He does not have, it's my understanding from speaking to him, he has not received the paper notice. However, the notice was sent via Federal Express to both the addresses listed, both the Dove Lane address and the In the Cut Barbershop address. He states that when he, went by the barbershop, there was a notice on the door for him to contact Federal Express, and he has done so. So he is participating by phone today and is aware of this hearing. However, I may have to read some documents into the record since he does not have the documents. It is my understanding that Mr. Rigsby wants to speak to the board and ask for a continuance of this hearing so that he can be here in person. I have explained to him that that is not necessary and legal would object to a continuance of this matter. Mr. Rigsby, now is your time, only as it relates to the continuance, to formally ask the board, if you so desire, for a continuance to be here in person and let them vote whether we go forward today or not.
Well, first off, I do want to apologize for the misunderstanding, and I would like to be there in person if I could. But if the board sees fit, that this must continue today, then I respect that also, and, I would just have to continue. But I would like to continue to be there in person. But I respect that if not, we have to take care of the day. I also respect that fact, too.
And just so the board and Mr. Rigsby are both aware, we have had these type of proceedings where the individual participates by phone in the past, and there is no prejudice to Mr. Rigsby attending by phone. This is a summary suspension, not a revocation hearing, where the board will hear the facts as presented. Mr. Rigsby will have an opportunity to respond to those, and the board will make a decision on a summary suspension. Just so the board is aware and Mr. Rigsby is aware, there is a procedure whereby we did not have to give Mr. Rigsby notice, could have gone forward with the summary suspension and then placed him on notice, but we chose to give him notice and do this on the regular board meeting. So again, legal would object to a continuance. I would need a motion to go forward.
Make a motion to go forward.
Second.
We have a motion and a second to go forward, and because this is telephonically, do we need a roll call vote?
Yes.
Thank you. Ms. Anita Charlton?
Yes.
Mr. Frank Ambusa?
Present.
Mr. Ron Gillihan?
Yes.
Ms. Yvette Granger?
Yes.
Ms. Judy McAllister?
Yes.
Ms. Janie Ross?
Here.
Ms. Patricia Richmond?
Yes.
Ms. Becky Russell?
Yes.
Ms. Amy Tansley?
Yes.
Ms. Mona Sappenfield?
Yes.
And everyone that is participating in our meeting has voted yes to the motion.
Motion carries.
Mr. Rigsby, based on the motion, we will go forward with the hearing, the informal hearing on the summary suspension today. And again, you will have an opportunity after you hear what I have to report to the board to speak to the board yourself. Do you understand?
Yes, ma'am, I do.
Okay. Specifically for the board, on September 21st, 2018, we mailed Mr. Rigsby and In the Cut Barbershop at the addresses previously provided a notice of informal hearing regarding summary suspension, both of his individual license and shop license. This notice provided the facts in which we intend to rely on today to ask the board to consider the summary suspension. I will go into the facts in greater detail. Specifically, as I stated previously, we gave Mr. Rigsby notice provided under TCA 45320, which provides and gives this board the authority to summarily suspend an individual and or shop or licensee if the board finds that the public health, safety, or welfare requires emergency action. As I stated earlier, this particular notice was provided to Mr. Rigsby at his last known address as provided to the board office. The specific facts that I'm asking the board to consider are specifically provided in the affidavit of complaint that you have paper copies of. The affidavit of complaint, which was provided by Officer Arnold and signed by him, specifically states that between the months of July and September 2018, agents with the 18th Tennessee Judicial Task Force and TBI conducted an investigation of Mr. Rigsby and his business In the Cut after multiple complaints of drug trafficking. Over the course of the investigation, the agents witnessed multiple hand-to-hand transactions in the parking lot of the barbershop and made multiple traffic stops leaving the barbershop in which vehicles were found to contain quantities of controlled substances. On 9/13/2018, agents with the Drug Task Force and TBI executed a search warrant on Rigsby's business and his 2015 Chrysler 200 that Rigsby was driving at the time. In the course of the investigation, it was found that Mr. Rigsby was in possession of 27 grams of cocaine, 51 grams of methamphetamine, 2 grams of marijuana, 2 digital scales, and approximately $1,400 in cash in 2 separate stacks. Due to the results of the investigation, Mr. Rigsby was charged with possession of Schedule II narcotic cocaine, 26 grams to 300 grams, for resale, possession of Schedule II methamphetamine, 26 grams to 300 grams for resale, and simple possession of marijuana and drug paraphernalia. It is my understanding from speaking to the detective and Mr. Rigsby that he has a court date on his criminal matters November 17th, 2018. Based on the facts that I have just provided and the affidavits of complaint, which total 4 pages, Mr. Rigsby has 4 separate charges, all drug charges. Based on that legal's recommendation, and we would ask the board to consider a summary suspension today and to place this matter in litigation monitoring until such time that the criminal charges are resolved. Mr. Rigsby?
Yes, ma'am, I'm here.
Now that you've heard the facts as presented, it is your time to speak to the board about this matter.
Well, first, I would like to tell the board, I apologize. I apologize for everything. Second of all, I'm not disputing nothing that they caught me with that day. I was wrong for that, and I've learned from that. I've learned from that mistake. Third, I've never sold nothing out of my barbershop. I poured too much money. I poured my savings into that shop, and I take pride in what I do. So I take my business very seriously. I have never sold nothing out of that barbershop. And when I asked the detective at the time that he told me that they had made these stops, they couldn't provide with me the names or the stops of nothing that they had pulled these individuals over. And the hand-to-hand contact, I don't have too many family members come to my shop. So all these accusations that I'm making, I asked him to provide me with proof that day that we spoke, and they couldn't provide me with no proof. I take pride in my business. I take pride in my work. Once again, like I said, I'm not downplaying the fact that what I got caught with. I greatly apologize for that. That's a mistake that I've made. I've learned from that mistake, and I'm still dealing with that mistake. But on the business side, once again, I've never sold a product out of my shop, illegal product of that matter. I've always treated my barbershop, my customers, and anybody else with the utmost respect. And you can go to Portland, you can ask anybody in Portland, they will tell you that guy is very respectable. He's very business-minded. And at the time when the news came out with the post, it was people coming on the post talking about this can't be true. Like, he's a good guy. I know this ain't true. And that's the truth. I've never sold a product out of my shop. Like I said, I take my business very seriously, and I take my professional life very seriously.
Okay. Did you have anything else, Mr. Rigsby?
No, sir. No, sir. No, sir, I do not. I would just like to say, I would ask the board not to suspend my license, but at the same time, I have to respect the fact that if that's what has to happen, I have to respect that, and I have to deal with that. But I just want you all to know that no illegal substance was sold through the doors of Indicut Barbershop. I treat my business very professionally. Like I said, I pour too much money into my barbershop to jeopardize it on something like that. So I will never jeopardize my business by selling an illegal substance out of my business, knowing what it's going to cause and what trouble it's going to bring me. So, like I said, I pour my savings into that shop, and I will not jeopardize my business nor my barber license by selling an illegal substance at those doors.
Thank you, Mr. Rigsby. Again, based on the information provided by the Drug Task Force and the TBI, which is contained in the affidavit of the complaint that has been recited to you today, legal's recommendation based on the board's authority under 62.3 TCA 62.3.121, which specifically provides that the board may refuse to issue, renew, or may suspend or revoke a license for specifically unprofessional conduct, further provided under 45320, if this board finds that there is an emergency action because of the public health, safety, or welfare being at risk, this board may summarily suspend both the individual license and shop license of Mr. Rigsby and In the Cut Barber Shop. legal's recommendation is to suspend this license and the shop license.
Would we need a motion on either on those individually?
Yes, and a roll call vote.
Do we have a motion on the individual license?
Just to confirm, this is a suspension until we have more information from the legal investigation, correct?
This would be a summary suspension pending the outcome of the criminal charges if we put it in litigation monitoring. Currently, there is not a complaint open. We will need to open a complaint administratively, and then the board would need to decide how we go forward. In cases like this in the past, we have simply placed these in litigation monitoring until such time that the criminal charges are disposed of one way or the other. However, Mr. Grigsby can request an immediate hearing on this matter. I don't know whether his intention is that he would agree to place this in litigation monitoring until such time that the criminal charges are resolved, or whether he would request, depending on what the board action is today, a more immediate hearing if the board decides to summary suspend today.
Thank you.
But to clarify, this is a summary suspension. We've done these in the past. The summary suspension stays in effect until such time that there is a hearing. In the past, you have lots of options. You can vote for revocation of the license when the complaint is presented, because we would have to come back and address the complaint on the legal report. At that time, his license still may be suspended, both individually and the shop license. And at that time, then you're making a decision what you want legal to do with the complaint. And at that point, he may still have criminal charges pending, and my recommendation may be to put it in litigation monitoring.
So at this point, we would need a motion for summary suspension and to place this in litigation monitoring.
I would make that motion.
We have a second by Ms. Ross. Is there any other discussion? All in favor, and this is the personal license, all in favor say aye.
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 And we do need a roll
I
call
will do
vote.
Oh, I'm sorry. Roll call.
But just to be sure, we've got a motion and a second, and this is on Mr. Rigsby's personal license, which is license 20237. So that is what we're voting on first.
Yes.
Ms. Anita Charlton,
Yes.
Mr. Frank Ambusa,
Yes.
Mr. Ron Gillihan,
Yes.
Ms. Wyvette Granger,
Yes.
Ms. Judy McAllister,
Yes.
Ms. Janie Ross,
Yes.
Ms. Patricia Richmond, Ms. Becky Russell,
Yes.
Ms. Amy Tansley,
Yes.
Ms. Mona Sappenfield.
Yes.
Thank you. All that are participating agreed to the summary suspension on the personal license.
Motion carries. For the shop license, and that number again, Roxana?
Yes, the shop license is, again, the barber shop is In the Cut Barber Shop, license number 11920. We would need a motion.
So we would, we would need a motion for summary suspension and litigation monitoring on this shop license as well.
I'll make the motion that we move forward with the summary suspension of the shop license.
Second.
We have a motion and a second to summarily suspend the shop license on this case and add the litigation monitoring. All those in favor say aye. I'm sorry, roll call again. Sorry.
Thank you. Ms. Anita Charlton,
Yes.
Mr. Frank Ambusa,
Yes.
Mr. Ron Gillihan,
Yes.
Ms. Wyvette Granger,
Yes.
Ms. Judy McAllister,
Yes.
Ms. Janie Ross,
Yes.
Ms. Patricia Richmond,
Yes.
Ms. Becky Russell,
Yes.
Ms. Amy Tansley,
Yes.
and Ms. Mona Sappenfield.
Yes.
Thank you. Unanimously vote is yes.
Motion carries.
Mr. Rigsby,
Yes, ma'am.
The board has voted to summarily suspend both your individual license and the shop license. You'll be receiving some paperwork from me. It is very imperative that you keep me informed on the status of your criminal charges. Do you understand?
Yes, ma'am.
Thank you.
Ma'am,
Yes.
could you change the address on that? Instead of 218, it's 309 Clark Street, please?
Mr. Rigsby, you'll need to contact the board office to update your address, but I will call you after this hearing is concluded and I finish my board business for today and get the address to send you the order of the suspension. But you do need to contact the board office to update your address.
Okay, that'll be fine.
Okay. Thank you.
Thank you.
That's all I have.
Thank you.
Thank you. We will go back to our agenda, and we stopped at page 165. I'll give everybody a chance to get back. We're still in the middle of our miscellaneous presentations. Okay. The first item is more of an update for the board. At the August board meeting, we presented 3 applicants applying for reciprocity of manicurist license from Georgia with transcripts that appeared to be fraudulent and had several errors on them. Since that time, each of those applicants has provided an error-free transcript, and the office has been getting more and more applicants coming through from that particular school each week, as opposed to the school currently under investigation. This particular school appears to be licensed. They have presence online as well. We have at least one example of an individual that has presented a transcript from both of the schools, the one that we've had an issue with many months ago and asked for clarification and investigation, as well as this one. So for that reason, we have been reviewing them a little bit closer. I have personally contacted the Georgia State Board via email and asked for a status update on the original school that we had concerns about, as well as this one, and to this time we have not gotten any update. Legal counsel is working on an updated letter that will go to them so that we can get an update for both schools, and in the meantime we are just not approving these hours for either one of the schools. Any questions or concerns? Okay. Thank you. On your iPads, you have a request for an extension of continuing education. This continuing education is for cosmetology instructor Ms. Sandra Renee Weisinger. Pursuant to Tennessee Code Annotated 62-4-114, an instructor must complete 16 hours of approved training program. It is at the board's discretion to approve up to 1 additional year extension for good cause. Ms. Weisinger has provided a letter explaining that her husband was diagnosed with cancer and that she's been occupied and stressed during this entire time due to this event as well as other things that have happened. Therefore, she was missing her continued education. The records indicate that she completed a session last in 2015. Her license expired in July 2018, and since she had not completed anything during that time span, the board released her license without the instructor part. She is registered to attend a session on October 13th and 14th, which would bring her current. She's asking for the board's consideration. And the doctor's note is on your iPad for review.
She's not already used her one-time extension.
She has not, and she hasn't attended since 2015. So normally we ask that they ask us timely, but given that 1-year language, the board could still allow this.
I'd like to make a motion that we grant her the one-time extension and that she completes her hours this fall.
Second that.
We have a motion and a second to grant the one-time extension for this applicant. All in favor say aye.
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 Opposed say no. Motion carries.
Thank you. Next, you have a request for extension of continuing education requirements for cosmetology instructor Teresa Patterson. The email communications with Ms. Patterson start, I believe, on page 176. Pursuant to Tennessee Code Annotated 62-4-114, an instructor must complete 16 hours of an approved training program. It's at the board's discretion to approve up to one additional year extension for good cause. She's provided an explanation about her ongoing health issues. I did this morning receive doctor's notes as well. I think on the email she says that they're available upon request, but she did send me paperwork. She completed the session in Memphis on September the 24th, and it's there that she heard me explaining the 2-year interval and realized that she was already late. Records indicate that she attended a session in August of 2016. Her license expired August of 2018, so she is technically 1 month late completing the session, but in her case, she already has taken it, so she's asking for the board's approval to have that count.
Motion to approve.
Second.
We have a motion and a second to approve this CE hours. All in favor say aye.
Aye.
Opposed say no. Motion carries.
Our last extension request, this is for also continuing education requirements from a cosmetology instructor, Lisa Wilkerson. Pursuant to Tennessee Code Annotated 62-4-114, an instructor must complete 16 hours of an approved training program. It's at the board's discretion to approve up to an additional year extension for good cause. She provided a letter explaining that she stopped teaching in June of 2016. She had planned to take the online course at the end of this year, and so since it is no longer available, she renewed her license in February 2018, but without the continuing education piece. She's asking for the board's consideration.
Motion we grant her the one-time extension.
Second.
We have a motion and a second to grant the one-time extension. All in favor say aye.
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 Motion carries.
Next on your iPads, we have an update on the director's report. The financial information requested, presented through June 2018 is on page 195. It shows an estimated surplus of $242,016 for fiscal year 2018 that has ended, but we don't have the final figures yet. So in November, I should have not only the final ending figures with any cost back adjustments, just minor changes, as well as the ending carryover for 3 or 4 years I think we get. So that will be presented. And then also you can see the month of July 2018, which reflects a total of $58,857 left over for that month. Any questions?
Motion to approve.
More information, I think,
Okay.
than anything, but I appreciate it. Thank you.
Good job.
Don't have a lot left over ever, but we're right there, so that's a good thing.
It's better than not having any left
That
over.
is correct. We all agree with that, absolutely. Next month at the November meeting, we will have all the 2019 continuing education requests for dates, so I definitely plan on having that presented. Ms. Granger, you attended one this session. I don't know if you wanted to update the board on it, and when I was also in Memphis.
Yes, I have a few words to say about it. I think that the PPC CEU classes were absolutely amazing. They were very interactive with Miss Celeste Harris and Pearl Walker. They engaged their audience through questions and made those learning tools. And they even did a little skit in professionalism and all that. So it was really cute, really fun. I absolutely saw no nodding heads, and I didn't think once, man, I could be doing something else. So
That's great.
yeah, it was good.
Thank you. Really appreciate that. We will continue, and the legal report will be at the end, giving Ms. Spicer plenty of time to get her order together. So on your iPads under New Business, we have on page 201. On September 18, 2018, Tennessee Academy of Cosmetology closed its 2 campuses located in Memphis. They provided students with a letter via email with information on how to reach them. They can be contacted through email or telephone to assist them through this process. Since that date, the board, as well as the Tennessee Higher Education Commission, THEC, has received Excel reports listing all of the students enrolled at the school at the time that the 2 campuses closed. I have been in conversations with one of the owners in particular, and then, of course, with many of the students that have gone through this horrible situation. The students were emailed withdrawal documents showing their hours, and all of their hours for those that were currently enrolled when this took place were released. A total of 87 students between the two campuses were affected. A few of those cases need hours to be corrected, and the school has, said that they would update those. That's not unheard of. Sometimes students forget to clock in, so we expect that we'll still be receiving those. 11 students from these two campuses were within 3 weeks of finishing their hours. I've got my notes wrong. 11 students were within just having started school in the previous 3 weeks. So it's my understanding that they have a method with which to get a refund because they barely started. 4 or 5 students were within a month of finishing their school. So you will see the letters for the students that have sent something in, and then the last 2 items, or close to the 2 items on the iPad, are the actual the spreadsheet for the 2 campuses. So the first student that we're going to be discussing is Ms. Megan Holcomb. She is an esthetician student. She is requesting the board waive the 70 hours she is lacking in order to take the Tennessee exams. She's presented a letter explaining her search. And again, we're presenting these. That doesn't mean that you choose to do this or that you can. It's our conversation, and we've got 3 students we're going to discuss here. So in her case, she has reached out to schools. She shows there what the impact financially will be, costing her a little over $1,000 out of pocket. And so that is her request. The following student is Ms. Kyra Salisbury, manicure student. She is requesting a waiver of 70 hours that she is lacking to take the Tennessee exams. Again, she's presented a letter explaining the undue burden. And the third student, you don't have on the iPads. I have brought her email communication with me and her situation. I'm actually presenting Ms. Samantha Bedford. She's a cosmetology student. She is requesting to be put through to take the PSI exam. She had completed 167 hours toward her cosmetology education in high school. She was unaware that these hours existed or were presented. She just didn't know how that piece worked. In email communications, and again, we've been via phone or email, as you can imagine, with at least 2-3 dozen students. So I made her aware that those hours were there, and on August 11th of 2018, she would have gone past the 7 years and technically just lost those. So if the board sees fit to have extended those hours, the 167, with the hours that she has at the school, she in essence would have more than 1,500 hours and be ready to be put through to take the exam. So her situation is a little bit different. I have her email. I don't have a problem sending everyone. It came in late Friday. She actually has not only lost her job that she was working at part-time, but been in an automobile accident, totaled the car, and she's about to have a baby in November. So I apologize that it's not on your iPads, but I couldn't not proceed with her situation. She is hoping to test before the baby comes, obviously. She is okay, and so is the baby, but it was really a bad situation from every aspect. So if the board's okay with discussing Samantha first, and then we talk about the pending hours and what we can do, if anything. And Samantha is on here on page 211. They show her at 1,167.97 hours. I don't have the updated withdrawal document, but she has a total 1,362 completed at that school, and then the carryover of 167 would put her over. So if the board is okay in motions, I can do a withdrawal document with, basically we can put her through to test because the hours will be there.
I make a motion to put her through the test for PSI. She has her hours.
Second that.
We have a motion and a second to approve her to test. Is there any other discussion? All in favor say aye.
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 Opposed say no. Motion carries.
Okay, so now we go back to, and these 2 students, like I said, are not unique. We've got 4 or 5 that were right there about to finish. I don't know how the board wants to handle. What I recommended to every student I've spoken to is to contact not just one or two schools in the area, but all the schools in the area, see what can be done. These students, as well as almost all of them, were on financial aid. So yeah, I'm sure they're contacting financial aid to find out if anything can be carried over, but they're already, 3 weeks, if not 4 weeks, behind on going to school. Both of them in their letter explain what they're, what's being accepted. I think one or a couple of the schools can't take all the hours because of their accreditation requirements, and so they're just at a difficult situation.
Roxanne, on page 211, is that the most recent hours that we have for them?
Yes, and I have confirmed with Ms. Jones that some of these are not accurate, that as the students have reached out and said, yes, but I came on this date and so forth, they've gone back and forth, that they're revising some of these. So in the case of Samantha, for example, I will not proceed until I get the revised. Instead of 1,168 hours, she needs to have the 1,362, and then it balances. But at least with her, I could see everything. I am going to let Sherelle speak. The only times that we've looked at school hours and debated have been on closed schools, obviously, have been in situations where we couldn't vouch for all the hours. But as Sherelle will point out, we want to have the conversation. You may not be able to do anything other than read their situation.
Okay. I'm looking at this, and I think there are definitely some concerns about your ability to waive the hours that are required under TCA 62-4-110. What I would like to do is closer look at that statute and see if that ability is there. I think these situations are very different in that these aren't reciprocity applications where you clearly have statutory discretion, and they're also not situations where records have been lost or destroyed. So this would be a situation where the board is on notice as to how many hours the students obtained and the shortage, and the students are asking for a waiver of those particular hours, and under the applicable statute that's directly on, there doesn't appear to be any discretionary language, but I would like to take a closer look at that and see if there's an option for the lacks that authority prior to the board taking that particular action.
Still in the Memphis area, is that what I saw?
Yes, both are. They're not that far from each other, I don't believe.
There are TCAT schools in Memphis, correct?
There are,
There
yes.
are, and I just checked to make sure that TCAT does offer cosmetology, and they do.
So there is a cost-effective option out there, and I'm not picking one side here or the other, but just for information, I guess. If a student is on financial aid, a calculation is done. Sometimes money is returned to the Department of Education. Sometimes it's returned to the student in the form of a credit. So unless you get into each individual scenario where you're looking to see did they receive a credit refund or something like that, then we don't really know if they have a true burden there, even if we had any discretion. If they want to attend in a privately owned school or something that has financial aid, they're going to run up against some of those regulatory standards of who can transfer in, what number of hours can be accepted in regards to accreditation and those things.
I would suggest that these students also look into the options for the Tennessee Reconnect, so not just federal, but Tennessee money. And I'd be happy to contact the TBR to notify them of an issue with these and see if there's some kind of accommodations that we can make for these students for the TCAT Memphis.
A great option. I don't know if they've got a wait list like other schools or they'd be able to make a difference, but yes, they run a fantastic
There may
program.
be exceptions that can be made, so we will I can talk to the TBR and see if there's anything that can be done.
If I could, just for a personal note on this letter that we have from the school that notifies the students of their closure and their abilities, responsibilities, that's a wonderful thing. That's what we'd like to see or what I'd like to see from any school that has difficulties, hopefully a little before they shut the doors, but sometimes that's not practicable. But I do want to commend them for having that out there and reaching out to try to walk these students through that. Again, as Sherelle said, it's not a case where we are questioning how many hours they have. There's still a few things that need to be sorted out, but the school has records and they're communicating those records and updating and doing the closeout process, it looks like, correctly. So.
With the, okay, is that going to be our motion for her to check and get back with you, or do you need a motion on that?
Are these students asking for a waiver of their hours? Is that what we're really at?
They are, and we did not want 15 students coming before the board, so I really selected those that were closer to the number of hours, again, keeping in mind that we've never really done this. As Sherelle says, you likely can't, but they wanted their case brought before you. They wanted their letter in front of you so you could see the situation. I think in this particular case, both reached out to other schools hoping that they would be able to afford and start school, and neither one was. I mean, it's a burden. And I think some of it is a time delay as well, not just the financial, because it could be that they're going to get some financial aid back. I hope, but I don't have that answer. That's not in our jurisdiction to assist. But they've got the right phone numbers. Definitely they'll reach out to see if the TCAT school that's there can take them on. And some have found schools. I think we have a couple of the smaller schools, and we have some specialty schools that have started them as of, I think, today. But it does set them back. There's no doubt.
We most likely don't have the authority to actually waive them. Do we have a motion to deny the request?
Deny.
And one thing that I would just put out there as an option, you all can table this, and that'll give us time to look into it and also give Ms. Russell the time to make some inquiries. You all can table these requests and we can revisit.
I'm going to withdraw it and move it to the table.
We have a motion to table. Do we have a second? We have a motion and a second to table this item. All in favor, say aye.
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 Good call.
Motion carries. Thank you.
And I will have the same motion for both applicants that we presented, and so moving forward, I believe what we will do, like they were the ones closer to finishing, if you will, is let them know that at the November meeting we will look at every avenue. If in the meantime, and I have said this as I've spoken to many of the students, you still have to pass those exams, right, to get the license. So sometimes even though you're almost there, that last part of the education is very important for the review process, for preparation for the boards, for putting all the pieces together. So a waiver may not really, maybe shouldn't even be the option if you really want to succeed, and not then spend 2 or 3 times trying to take the theory and having that really add to the heartache you're going through. So in some cases, I think our conversations with the students have been good from that perspective, but it's a difficult situation either way. Okay, so we are on to the last part of our iPad, and we will do legal at the end. I'll turn it over to Sherelle. This is the rulemaking, where we stand and what else needs to be done to move this forward. Thank you.
Okay, if y'all bear with me for one moment. Okay, if you look to page 212 on your iPads, these are the equipment rules that are before you. You all previously reviewed these rules and adopted them, but upon reviewing these internally, there was a suggestion for a substantive change that was that was meritorious and that was made to these rules. And because it was a substantive change, I'm bringing these back before you. I will note for the record that there are red line copies in the back of the room on the table. Is there anyone here at the meeting today who would like a copy but did not receive one? I'll note for the record that there's no one who would like a copy but
I'd
did
like
not.
to take a copy with me.
Okay.
I didn't hear the question. I was too busy reading. Yes, I would like a copy.
Okay, and that's really directed to the audience because of a new statutory requirement related to red lines, but I will definitely make sure you all get copies to take with you as well. Is that just Frank and Wybet? Okay, everyone. Okay.
If you shoot us an email,
Might as
would
well
it be
give
easy
everybody
to
an
email
email,
it?
it's fine.
And that's been
Email?
emailed. I just want to make sure
Email.
that everybody got the red line we emailed. Okay, so we'll print them.
So we can provide
Have you
you all
emailed
with
us
a printed
already?
copy to take with you as well. But the substantive change that was made, there was language deleted. It was on both the barber and the cosmetology side, and it would have been on page 8 and page under the section about instructor training programs. And what that particular change was, the board originally had in there the option to charge if internally our inspectors had to, in essence, do an inspection of a virtual program similar to its physical inspections that it does of schools. And so there was language in there that the board would hold the applicant responsible for any costs associated with such internal reviews. And that language was a little bit concerning just from the perspective of it. Just from the perspective of it potentially being a fee to individuals that would not have a definite amount. And so I thought that the best way for the board to move forward with the rest of its rules is to take that particular provision out and move forward. And so that's why these are coming back before you today. That was the substantive change. Any other changes were minor, numbering, grammar, things like that. But this was the substantive change and why you're looking at them today. Did you all want to discuss that particular provision that's been taken out, or do you feel comfortable voting and we would need a roll call on adopting this particular set of rules?
That's the only other change that was new outside of our discussions.
Yes, that was the only substantive change. Everything else was minor. Sometimes we use the word teacher. We change that to instructor, spacing, little minor things that you catch with this rigorous editing process that we have. But this was the only substantive change, and that's why we need your reapproval of these rules to accept that change or further discuss it if you all have questions or concerns.
How do we feel? Do we have any questions on that? Do we need to?
So in essence, the board would continue business as usual. There wouldn't be this authority to charge a fee, but it's something that the board can revisit if it becomes an issue of resources being allocated to it that would need to be addressed in the future.
Specifically for the virtual instruction courses?
Yes, that language specifically dealt with the online, virtual, or electronic instructor programs only.
Changes or additions to this document at this time, other than the minor things you listed as well?
That's correct.
with moving to approve. But I mean, I have not read the rest of the document. I'm assuming that the rest of the document has been previously approved by us.
We have a motion to approve. Do we have a second?
Second.
We have a motion and a second to approve. Any other questions or discussion? All in favor, say aye.
Aye.
Oh, you say roll call. Roll call.
Roll call.
We'll do a roll call again. Sorry about that.
One more time. Last one, I think. Ms. Anita Charlton?
Yes.
Mr. Frank Gambusa?
Yes.
Mr. Ron Gillihan?
Yes.
Ms. Yvette Granger?
Yes.
Ms. Judy McAllister?
Yes.
Ms. Janie Ross?
Yes.
Ms. Patricia Richmond?
Yes.
Ms. Becky Russell?
Yes.
Ms. Amy Tansley?
Yes.
Ms. Mona Sappenfield?
Yes.
All in agreement. Thank you.
Thank you. That would conclude my discussion of the rules. I will go ahead and proceed with routing these internally as they're currently drafted, and we'll update you all periodically on the status. Thank you.
Thank you. And now I think for the last part that we've got is going back to the legal report on your iPads, and that is a separate presentation. So if you'll touch the upper left-hand corner, you'll be able to see the two items under the library, and I'll turn it then over to Ms. Pamela Spicer to complete legal.
Good afternoon. The committee met this morning to discuss the legal report, and there were no changes, and it was adopted. But if anyone has any questions this afternoon about the legal report, I'll be happy to answer any questions that you have.
Motion to approve.
Yes.
Okay.
Make a motion to approve.
Second.
We have a motion and a second to approve the legal report. All in favor, say aye.
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 Motion carries.
Thank you.
Thank you. I have nothing else.
Oh, we got finished at noon.
Wow. Surprise.
Close it up before you say anything.
Yeah. I'm going to make a motion, Frank.
Hit the gavel, then talk.
I'll make a motion to dismiss, adjourn.
Second.
Motion and a second to adjourn. All in favor, say aye.
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 And that's not a roll call. Motion carries.
Now, what were you saying, Ron?
Now then.
Wow.
Ain't over till it's over.
You need some
awesome.
signatures.
Thank you for your work.
See, when you're efficient.